Your phone is ringing more than it ever has. Somebody just bought an electric vehicle and they need a level 2 charger installed in their garage this week if you can do it. It's a one-day job, really good margin. The customer already bought the unit. All you have to do is run the circuit and hang it on the wall. Here's the question nobody is asking before they take that job though. Does your license actually cover it? Not, can you do the work? Of course you can. You've been bending conduit since before some of these EV companies even existed. I mean, does the classification printed on your license and the project limits that come with it cover this job at this location at this contract price? Because right now, all across North Carolina, charger installations are being done by handymen with no electrical license at all, and by licensed contractors quietly working outside their classification. And when one of those installations fails inspections, or worse, starts a fire, the State Board of Examiners of Electrical Contractors doesn't ask whether you were capable. It asks whether you were authorized. My name is Nick Dogle. I am a North Carolina attorney, and my firm, North State Law, focuses on professional license defense. We represent licensed professionals across the state, including electrical contractors, when their license and everything that depends on it is on the line before their licensing board. If you're an electrical contractor in North Carolina, or you're a handyman or general contractor who's been asked to install a car charger, this video is for you. I'm going to walk through how North Carolina's electrical contracting licensing classifications actually work, why EV charger installations are becoming an enforcement problem, and the specific mistakes that turn a one-day job into a board investigation. Let's talk about why this issue exists in the first place. Because it's not the board being petty about paperwork. An EV charger looks simple from the outside. It's a box on a wall, right? But electrically, a level 2 charger is one of the largest continuous loads you can add to a house. It can pull as much power as a central air system, sometimes more, and it runs for hours and hours at a time. That raises real questions. Can the panel hold it? Was the load calculation done? Is the circuit size right? Is the equipment listed and installed to code? Get any of that wrong and the failure made isn't a tripped breaker. It's overheated conductors behind drywall. That's what the board exists to protect against. The licensing law isn't a jobs program for electricians. It's a consumer protection statute. Ask them, they'll tell you. And when a new category of work explodes in volume the way charger installs have, two things happen. Unqualified people rush in, and the board starts paying attention. And add in the fact that failed installs generate insurance claims, and insurance investigators are very good at asking one question early. Who did this work? And were they licensed to do it? Start with the baseline. In North Carolina, engaging in electrical contracting requires a license from the State Board of Examiners of Electrical Contractors. That is statutory. It comes from Chapter 87, Article 4 of the General Statutes. Installing an EV charger means running at a new branch circuit, often adding a breaker, sometimes upgrading a panel. That is electrical wiring work. It is not handyman work. It is not installation of an appliance. And buying the charger at a big box store does not change what the wiring behind it legally is. There are narrow exceptions in the statute. For example, a property owner doing certain work on their own property. But those exemptions are very narrow. They're construed narrowly, and they do not cover someone doing this type of work for compensation as a business. Now the layer that trips up even licensed contractors. North Carolina doesn't issue one flavor of electrical license. Licenses are issued in classifications: limited, intermediate, and unlimited, plus a set of special restricted classifications for specific kinds of work, like low voltage systems and photovoltaic work. The classifications carry different qualification requirements and different limits on the projects you can take, including monetary project limits set under the statute and the board's rules in Title 21, Chapter 18B of the Administrative Code. Let me make this concrete. This is a hypothetical. This is not a real client and it's not a real case, okay? I don't do that. If you watch any of these videos, you know that. Derek runs a handyman business outside of Wilmington, North Carolina. Customer buys a charger online and offers Derek $800 to install. Derek's done plenty of small electrical jobs. He's swapped outlets, hung ceiling fans. He figures this is the same thing, right? Just bigger. He runs the circuit, lands it in the panel, mounts the charger. It works fine. 6 months later, the homeowner sells the house. Buyer's inspector flags the unpermitted circuit and the question of who installed it lands with Derek's invoice attached in front of people whose job it is to enforce it. Derek doesn't have a license to defend. What he has is exposure to an unlicensed practice allegation, which in North Carolina carries potential criminal consequences, plus injunction authority the board can and will use to shut the work down. Now, the version of this that keeps licensed contractors up at night, because Derek at least knew he was winging it. The more dangerous trap is the contractor who has a license and assumes the license is the whole answer, right? Another hypothetical. Marcus holds a limited classification electrical contracting license. He's built a solid residential business and residential charger installs have become a nice line of work for him. Then a property management company called. They want chargers installed across the parking deck of a commercial property. Dozens of units, panel upgrades, new feeders, a contract price well into 6 figures. It's the biggest single job Marcus has ever been offered before. Here's the problem. The limited classification carries a per project monetary limit under the board's rules. The exact dollar figures are set by statute and rule, and they change over time. Check the current numbers before you quote anything. But the structure is the point. A limited license is not a license to take any electrical job at any size. When Marcus signs that contract, he isn't just stretching. He's engaged in electrical contractor work beyond what his license authorizes. And that doesn't matter that his workmanship is flawless. This is the part professionals misunderstand the most. The board doesn't grade on craftsmanship. A perfectly executed installation performed outside of your classification or above your project limit is still a violation. Quality is not a defense to authorization. This is where most professionals get into trouble. And it's usually not the original job. It's what happens afterwards. First, skipping the permit because it's just a charger. A new dedicated circuit for a major load is exactly the kind of work permitting and inspection exists for. Every unpermitted install is a time bomb that goes off at resale, at refinance, or at an insurance claim. Second, paperwork gymnastics after the fact. The contractor who gets a letter from the board and then goes back to clean up the file. Backdating a load calculation, pulling a permit after the complaint, rewriting an invoice so the job description looks smaller than it actually was. Understand something. The underlying violation might have been a conversation with the board. Altering records after notice is a different category of problem. It converts to a competence question into an honesty question. And honesty questions are what end licenses. Third, treating the board's letter casually. Contractors call the investigator to explain, talk for 45 minutes, and volunteer 3 problems the board didn't even know about. An investigator is not a customer service dispute. They're not your friend either. Everything you say is part of their record. They're going to write it in their little report. And fourth, the referral trap. A licensed contractor lets an unlicensed buddy do charger installs under his license. Maybe pulls the permits for him. We'll talk about permitting in depth in another video. But know this, lending your license in substance, not just in name, is one of the fastest ways to turn someone else's work into your discipline. So how does a charger install actually become a case? Almost never because an inspector was just wandering around the neighborhood. It starts with a complaint, a homeowner whose charger trips constantly, a competitor who lost the bid and knows your classification, or a homeowner at resale, or an insurance carrier working backwards from a loss. The board has statutory authority to investigate, and the process is more formal than most contractors expect. There may be a written inquiry, a request for records, contracts, invoices, permits, load calculations, and eventually, if it proceeds, a disciplinary process that can end in reprimand, restriction, suspension, revocation, fines, probation, things of that nature. For unlicensed practice, the statutes go further: criminal exposure and injunctions. And running parallel to all of this is the civil side. An unlicensed contractor in North Carolina can find that the contract itself is unenforceable, meaning you did the work and may have no legal path to actually be paid for it. The pattern I want you to see: the install takes a day. The consequences run on a completely different clock, and they compound based on what you do after you're on notice. Let's shift from fear to control, because all of this manageable if you deal with it before there's even a complaint, right? Generally speaking, the contractors who never see the board have a few habits in common. They know their classification cold, not what they remember from the exam, but what their license authorizes today, including the current project limits, which they confirm with the board directly when a job is anywhere near the line. They pull the permit every time, and even on the easy jobs, because the permit is the cheapest liability protection in the trade. They document the load calculation on every charger install and keep it in the job file. And when a job is bigger than their classification allows, they either pass on it, partner properly with a contractor whose license covers it, or upgrade their classification in the legitimate way by qualifying for it. And if a board letter ever does show up, in many cases, the single most consequential decision is what you do in the first week before you respond, before you call the investigator back, before you touch a single record. What we often recommend is simple: get guidance before you respond, not afterward, right? Here's the risk in one sentence: the EV charger boom is producing a wave of electrical work performed by people who are capable but not authorized. And the board enforces authorization, not capability. The takeaway here is, before you take the next charger job, know exactly what your license covers and never let a good month of installs talk you past your classification. None of this means the board is out to get contractors. It means the system is unforgiving of shortcuts, and it rewards the contractors who respect the lines. If you're an electrical contractor and you've received a letter, a complaint notice, or an inquiry from the State Board of Examiners of Electrical Contractors, consider getting guidance before you respond. That first response matters more than most people realize. And if this video was useful, go ahead and check out the next one that we have lined up for you, because that'll give you even more information to help protect your license in the future, okay? So please take a look at the next video that we have. Thank you so much for keeping the lights on for North Carolina. Bye-bye.